People have the witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Valvo.
Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a scram tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people?
Your Honor, we have concerns about involved like including. I would note that it's not just one incident; it's 2 different days, and that the report indicates that when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those 2 on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down, he also then blew.
Let's pause for a second. This is a probable cause conference. That's basically a check-in where the judge decides what happens next. At first, everything looks normal. Names, dates, paperwork. Nothing exciting. But if you've seen court videos before, you know the calm never lasts.
And numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol related involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to violate it multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really substance.
And here it is, bond revoked. In simple terms, the judge said no more chances. There were too many problems, rule violations, alcohol use, missed tests. Judges see this all the time, and eventually they stop giving warnings. You can feel the moment shift. The defense hopes, the prosecutor pushes back, and then custody.
Abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He's here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No, just at my church. I don't have proof for it though, and I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks? Bond revoked, defendants remanded. Your name?
Melissa Kowinski.
All right. What are we doing in this case?
Your Honor, we're asking for an adjournment for negotiations and to review videos.
You've seen the bond violation report.
Yes, Your
This is where things get emotional. Melissa starts talking about her life, addiction, abuse, trying to get better, then slipping again. Judges hear stories like this often, but her honesty really stands out. Still, feelings don't erase danger. Then the prosecutor drops a big fact. Her past blood alcohol level was 0.280. That's extremely high.
Honor, and we have discussed it, and I'm ready to address it when the court is ready.
Yes, I'm ready to address it.
Ms. Konwinski stated that she did drink, but it was only that one day. This was a one-day slip-up. She didn't take the test within 15 minutes because she fell back asleep. She takes mental health medications at night, which has been reported to CMH, which make her fall asleep. She wasn't avoiding calls. One of the numbers that she gave was her boyfriend's number, and he said that he didn't receive any calls. The other number no longer works. She did believe they have her current number, but that phone only worked on Wi-Fi, but she recently got it switched to a phone with a SIM card, so now works all the time. This Saturday, the 30th, she returns to work at Dunkin' Donuts. On the 11th of September, she will start a part-time inventory job. She also receives her Vivitrol on the 11th. On September 22nd, she has an appointment for mental health addiction recovery and an evaluation with IHA Trinity Health. She has been going to AA and has proof. Her letters of recommendations from
How long has she been going to AA?
she has the proof.